Trustees for Alaska was founded on December 16, 1974 by Rod Cameron and Peg Tyelson. They recognized how badly Alaska needed legal representation for the state's environmental protection. Our founders knew that in order to protect Alaska's lands, water, wildlife, and communities, we needed the ability to go to court. And in order to do that, we needed lawyers. As trustees formed, work had already begun on the Trans-Alaska Pipeline. Corporate greed and political opportunism saw Alaska as a cash cow. One of Alaska's most important lawsuits challenged the Alaska Homestead Act, which would have privatized huge amounts of public lands in the state. Trustees challenged that initiative and won in the Alaska Supreme Court. In 1981, trustees filed our first major legal action that threatened the Arctic National Wildlife Refuge. The case stopped the Department of Interior from transferring the management of part of the refuge from the U.S. Fish and Wildlife Service to the U.S. Geological Survey. And again, we won. Trustees has made a name for itself. It is recognized as a force to be reckoned with because of our strong staff and dedicated supporters and the long list of successful legal actions. Trustees started strong and has grown stronger and more effective through the intervening years. 3 cheers for trustees.
The Exxon Valdez oil spill dominated the news in 1989 and had lasting impacts on marine life for decades afterward. Trustees responded to the spill to make a difference in how oil is transported. Trustees' legal work led to several successful lawsuits in 1990 and 1993 that ultimately prevented oil and gas lease sales in Camden Bay and Demarcation Point in state waters off the Arctic Refuge coast, and have prevented oil activity in these waters for over 30 years. In 1983, over 600 placer miners were operating in the state. Mining discharges greatly impacted wetlands, reducing the suitability of water for drinking, domestic use, and as waterways where fish could thrive. Trustees would continue to fight against harmful mining practices for decades to come. Trustees brought a Clean Water Act citizen suit against several oil companies operating in Cook Inlet in 1995. There were over 4,200 toxic dumping violations against Shell, Marathon, and Unocal. The oil companies settled and directed almost $1 million to establish Cook Inlet Keeper, in turn allowing a community to form around the shared goals of monitoring and safeguarding Cook Inlet water quality. Trustees filed a lawsuit in 1994 against the state of Alaska for violating the Clean Water Act in their attempt to build a road from Chitina to Cordova. Former Governor Wally Hickel called it the Copper River Highway. The Copper River watershed remains largely roadless still today.
Interest in the Pebble deposit emerged in the 1980s, but legal battles intensified when Northern Dynasty began exploration in the early 2000s. The proposed mine, situated in the heart of the Bristol Bay watershed, posed significant threats to salmon, wildlife, and traditional hunting and subsistence practices. Several Alaska Native villages swiftly passed resolutions opposing the project. Trustees and allies mounted a strategic legal and advocacy campaign to prevent the mine's devastating environmental and cultural impacts. The fight continues today. Trustees took on another mining challenge to fight the proposed Chewitna coal mine near the Chewitna River and the communities of Tyonek and Beluga. In 2007, we filed a petition asking the state of Alaska to designate the Chewitna River watershed unsuitable for coal mining, responding to local concerns about protecting clean water and salmon. But the state repeatedly delayed or dismissed petitions and allowed temporary water use permits for mining, prioritizing that over salmon. Trustees and the Chewitna Citizens No Coalition challenged these decisions and won. While the threat of the Chewitna mine persisted, these legal victories stalled the project and reinforced Alaskans' commitment to safeguarding their environment and way of life. Trustees secured endangered status for Cook Inlet belugas in 2008 under the Endangered Species Act, ensuring federal protections against harmful industrial activities like Chewitna. Despite the state of Alaska's failed legal challenge, the listing remains a critical safeguard for the population. Since the 1990s, Alaska has expanded predator control programs on state lands, viewing wolves and bears as competitors for moose and caribou. We first challenged one such program in the mid-2000s.
Our fifth decade continued to bring independent science and legal expertise together, strengthening court arguments and helping us give agencies important scientific data and research. This work extended throughout the scope of our work, from coal to industrial roads. Our innovative legal work supported a coalition of people and groups that stopped the proposed Chewitna coal mine that threatened salmon and local communities in Cook Inlet. The win that safeguarded the Chewitna River region came in the form of an email from Pac Rim Coal. In the Arctic Refuge, we won in court and kept the state of Alaska from doing oil exploration in the coastal plain. Years later, in 2020, we challenged the legally troubled environmental review of the Arctic Refuge leasing program and went to court to defend the suspension and cancellation of ADA's low-bid leases from the January 6, 2021 lease sale. We also provided extensive input for a supplemental environmental impact statement that attempted to fix the legal problems in that leasing program. Oil leasing is antithetical to protecting the Arctic Refuge. Congress needs to change the law once and for all. We got a big win in 2020 when a district court judge voided the profoundly flawed Trump-era approval of ConocoPhillips Willow oil and gas project. The Biden administration later reapproved the massive oil and gas hub, and we sued again in 2023. We're still waiting for an appeals court to rule on that case. In another Arctic win, an appeals court ruled in our favor when we challenged a federal regulation allowing oil and gas operators to harass southern Beaufort Sea polar bears on the North Slope. This would mean injuries and even deaths to cubs and a vulnerable polar bear population. The court ordered the agency to correct its legal errors. We sued several times to stop land trades that would swap public wilderness lands in Eisenbeck National Wildlife Refuge to make way for a commercial road. Such a swap, if left unchecked, would threaten national parks, refuges, and wilderness areas across Alaska by letting an Interior Secretary make land trades to benefit private interests. We won our 2019 case and argued our 2021 case in the Ninth Circuit Court of Appeals. Interior later withdrew the land swap agreement, making the second case moot, but then re-released a new analysis and decision in 2024 that supports the exchange. The Army Corps of Engineers denied a key permit for the proposed Pebble Mine in November 2020. About 3 years later, the Environmental Protection Agency issued Clean Water Act protections for Bristol Bay, essentially prohibiting any large-scale mine like Pebble. Though the Bristol Bay watershed is protected from the Pebble proposal for now, litigation and advocacy continues. Alaska livelihoods and ways of life depend on the thriving salmon runs nourished by the region. In 2020, we challenged a federal rule that would open national preserves in Alaska to hunting practices like killing brown bears over bait and killing wolves during the denning season. That lawsuit paused while the Park Service reviewed and proposed a new rule, which they issued in 2023. That new rule banned bear baiting, but failed to provide other protections. We continue to oppose predator control and hunting practices on federal lands that don't stand up to science and the law. We provided extensive input to the Bureau of Land Management when advocating to continue protections for 28 million acres as laid out in the Alaska Native Claims Settlement Act. These areas across Alaska were set aside as safeguarded from mining and mineral leasing. In 2024, the Bureau put to rest the Trump-era proposal to open these lands to industry. We went to court in 2020 to challenge permits issued for the Ambler Road proposal. The 211-mile industrial corridor on the south side of the Brooks Range in the Arctic would threaten North America's largest protected and roadless region, as well as the food security and clean water of Alaska Native communities. We gave extensive input to Interior when the agency released a new analysis. We celebrated with clients and partners in 2024 when Interior chose the no action alternative, which means no permits for Ambler for now. We know industry and political interests will continue to put pressure on exploiting Alaska across all these places and proposals, and then some. Big challenges and big wins defined our 5th decade and will in the decades to come, as we continue giving a legal voice to those striving to protect Alaska.